Good day, Leonard Silks, Leonard colleagues, and welcome to today's session. Please, we'll be commencing shortly. Let's give more of our colleagues just an extra minute to join us. This is 2 minutes past 2, would commence at exactly 3 minutes past the hour. Thank you for joining us. All right. Once again, good day, Leonard Silks. Good day, Leonard colleagues. On behalf of Tobena Erojikwe, the chairman of MBA Institute of Continuing Legal Education, I welcome you all to day 3 of this 7-day training program on debt recovery and asset tracing. We've had 2 insightful presentations so far in the last 2 days, and I bet today's is not going to be any different. So today's session will focus on strategies for settling debt disputes through mediation and negotiation. And to do justice to this topic is no less a personality than an exceptional expert in the field. He is a very senior and experienced practitioner. He is Dr. Agada John Elachi, Senior Advocate of Nigeria. Before I yield the floor to our most esteemed speaker and facilitator, please permit me to read an abridged version of his citation for those of us who may not know him very well, though I believe that many of us in this space know him very well. So, Dr. Agada Elachi is a practicing lawyer and a senior advocate of Nigeria. He holds a doctorate degree in public policy and administration, specializing in terrorism, mediation, and peace from Walden University, United States of America. He also holds a master's degree in peace and conflict studies. He is an ADR expert with a bias for mediation and arbitration. He holds a fellowship of several professional bodies, including the Institute of Chartered Mediators and Conciliators, ICMC, Nigeria, the Chartered Institute of Arbitrators, United Kingdom, and the Society for Peace Studies and Practice, PSPSP. He also holds a diploma in international commercial arbitration. He's a certified trainer in mediation, arbitration, and dialogue and conflict resolution processes generally. He is on the panel of neutrals of Global Mediation United Kingdom, Kigali International Arbitration Center, Nigerian Chamber of Commerce Dispute Resolution Center, Nigerian Communications Commission, Federal High Court Alternative Dispute Resolution Center, and several multi-door court houses. He is a member of the Permanent Court of the Geneva International Dispute Resolution Institute. He is the immediate past president of the Institute of Chartered Mediators and Conciliators, ICMC, and a live member of the Governing Council of ICMC. Dr. Elachi also served as chairman of the Nigerian Bar Association Abuja branch. He was a member of the executive committee of the Chartered Institute of Arbitrators, United Kingdom, Nigeria branch, and also served as chairman of the ADR committee of the Pan-African Lawyers Union, PALU. He is currently a member of the interim management committee of the African Mediation Association. I could go on and on and on and on. Ladies and gentlemen, I present to you Dr. Agada Elachi. But before I yield the floor to our esteemed speaker, please just permit me to deal with some housekeeping issues. I reckon that most of us will have questions in the course of the presentation. I admonish you to keep your gunpowders dry. If you look at your screen, you see the Q&A tab as usual. You can post your questions there. Don't post them in the chat room so that it'd be easy for us to retrieve the questions. So I think that is all for now. So I'll yield the floor to our speaker, and then thereafter, at the end of the presentation, we'll take all the, or as many questions as possible, not necessarily all the questions. Leonard Silk, you have the floor. Thank you very much. You're welcome, sir.
Thank you, Dr. Odofia. And before I start, may I say a big thank you to the Nigerian Bar Association CLE program for ICLE program for inviting me to share some thoughts on an area of practice that I'm particularly very happy about and very excited at any given opportunity to speak on. I also want to thank my friend, Mr. Tobena, for approving that I use this platform to, of course, share knowledge. As I always say to those who know me, knowledge is a gift, and when called upon to share it, we should gladly and willingly share it. My task this afternoon is to take you on a journey into strategies, or to discuss strategies for settling debt disputes using mediation and negotiation. I'm aware that on Monday, Tuesday, and Wednesday, I think that this is day 4 or day 3, you've had the opportunity of learning a lot about debt recovery using other mechanisms, particularly debt recovery litigation. But for our purpose, I'll be talking about these 2 ADR mechanisms as ways that we can, of course, hopefully manage debt recovery better. So please confirm, Dr. Odofia, that I'm sharing my slide. I hope that
yes, you're sharing at full screen.
Thank you very
clear,
much.
Sir.
All right. So we'll start by having what are the expected learning outcomes from this brief conversation that we'll have for the next 40, 50 minutes or thereabout. I'm hopeful that we'll have an understanding of what debt disputes are. Indeed, I presume that you already have an understanding of that based on the previous lectures that you probably have received. We'll talk about the differences between negotiation and mediation. We'll talk about the advantages and disadvantages of negotiation and mediation. We'll talk about the strategies for effective negotiation and debt dispute resolution, the role of negotiation in the mediation process, and then how to effectively resolve debt disputes through mediation and negotiation. That should be negotiation. Forgive me, I have a bias also for arbitration. So occasionally my hand types arbitration instead of negotiation. Again, I would like to take it for granted that you already know what, when we say what is a debt, but then because some people may just have joined today and did not have the privilege of joining in the previous day, let's just, for the purpose of this conversation, say that a debt is a sum of money owed from one person to another, typically based on a contract or an obligation. So if it's a contract, a service has been offered and someone has offered that service in exchange for some money to be paid. If the money is not paid, it becomes a debt. And particularly for those of us who are lawyers, I can situate it within the context of the services that we offer to our clientele. So if as a lawyer, I have been retained by a client to conduct a case or to frank an agreement, to draft some documentation, to facilitate a particular transaction, and we have agreed on a fee note. Once my assignment is concluded, then of course, I'm entitled to be paid my fees. In some cases, I may not have concluded. Then the issue of quantum merit, the amount due to me for the amount of work that I've done, then comes to play. That is what, in essence, is being referred to here as a debt. Debt also encompasses the debtor's obligation to pay and the creditor's right to enforce that payment. And this was expressed in the decision that, as you see there, in NIPOS versus IBOC Nigeria Limited. The citation is there, so I'll leave you to look it up at your convenience. Now, when does the debt become due? Again, this was clearly stated and addressed in the case of Wema Bank versus Owosho. It's a 2018 case, decision of the Court of Appeal. But just to say that when the creditor formally a debt becomes due either when the creditor formally demands for payment or when does the debt become due. For me, I would say that adhering to this principle is crucial for legal debt recovery processes. If you go through your Legal Practitioners Act, it says clearly that as lawyers, we must make a demand for payment. So, for instance, if you are suing for your fees and you fail to make a demand for payment, you have not met a condition precedent, which makes the debt become due. You can apply this also on behalf of your clients who are involved in other transactions. So essentially, yes, while it's presumed that, well, if I've performed the service and there's a contract to that effect, you should act on it. What I do as a matter of practice is always to document the formal demand for the payment. And once that formal demand is made, then payment of the debt becomes due. This is also important, taking into consideration the fact that in some contractual arrangements, the issue of interest, there's an interest element that is that you can claim for. And so if interest element is one that you can claim for, then you should be able to make a formal demand so that at least you can begin to calculate your interest from that day. It is recommended for creditors to follow this fundamental rule when collecting debts. And so that's my recommendation to you, my colleagues. What are the possible reactions to a demand for payment? When someone makes a demand for payment, what kind of reactions are you likely to get? In a number of cases, in fact, to a large extent, close to 50% of cases, you are likely to get an admission. Admitting to the debt is common and leads to an arrangement for payment. So typically, that is what you find when somebody makes a demand for payment. Failure, of course, to dispute a creditor's written statement of amount owed implies an admission. And this was what the court said in Ife Messia versus Ecobank. So again, as lawyers, we must keep this in mind. And as we advise our clients, or if we are the ones found in that situation, that when a demand for payment is made, silence or your refusal, your neglect to dispute that claim can be treated as an admission of the demand for payment. Of course, denial is another way that debtors react to payment, demand for payment. In some cases, people counterclaim. So, and this is very funny. Many times, a debtor is quiet and pretending that they're wishing away the debt. And when a creditor then makes a demand, that is when the debtor remembers that, oh, I can actually counterclaim. It is also possible that they may have a legitimate concern, a legitimate claim. In some cases, maybe they have kept quiet so they can push for a set-off, as the case may be. And that is what number 4 refers to. Acknowledging the debt, but proposing to set off what is owed to the creditor against what they are owed. So these are all instances of possible reaction to a demand for payment. And because of what is in terms of indebtedness duration, why is this important? What do we mean by indebtedness duration? A debt from a civil contract becomes statute barred after 6 years. So it is important that you keep this in mind and all that. So where somebody undertakes services, and again, for us as lawyers, for instance, let's situate it within our profession. So I have carried out an assignment for a client. It is due, and then I do not enforce that debt after 6 years. Even though I may still have the claim is now statute barred. So it's important to keep that in mind. But the admission of that debt revives the cause of action. So if for instance, 5 years and 11 months and 29 days, I have kept quiet, and then I wrote a letter to the client or to the other party, to the debtor, and that person admits, it revives the cause of action. So it's important to keep that in mind. The date of admission determines when the clock starts for the limitation period. And that's what the case of, as stated there on the screen, talks about. There are also definitive circumstances determine what may constitute an admission. So, so you need to be careful what you presume is an admission. Sometimes silence in itself, again, depending on the circumstance, may not necessarily connote admission. Then let's talk about debt recovery. Having given this background, well, conflicts are inevitable and require solution to maintain relationships. Litigation in terms of debt recovery can be, as experience has shown, and I'm sure from the previous, unfortunately, I couldn't join the previous presentations yesterday and the day before, but litigation can be inefficient and lengthy, especially where the debt is substantial. My office is currently involved in two particular matters where we are pursuing debt now, and we have been on those matters in one case for 13 years. We're in the appellate court, and in another case, we have been there for about 6 years. So it could be quite tedious and quite frustrating. Arbitration is an option because arbitration deals with contractual disputes. But of course, arbitration, and I love arbitration, I'm a practitioner, but arbitration usually also comes at a huge cost sometimes to the parties. So again, this is, when we're talking debt recovery, you have to keep that in mind. So that then leaves the stage for mediation and negotiation as essential alternatives for resolving debt recovery disputes efficiently. And it is interesting to note that the advantage of litigation and mediation and negotiation as processes that can help, and indeed arbitration, for instance, in debt recovery is not something that is new. And for those whom I've had the opportunity of speaking to either privately or on using such fora, I have always referred to the great Mahatma Gandhi, who in the year 1800, in the 18th century, or was it the 17th century? No, I can't remember. No, I believe it was the 18th century, was able to advise his clients to take arbitration as an option for resolving a matter rather than going through a lengthy and very tedious litigation process. It is also interesting to know that at the end of that arbitration, when the award was rendered, enforcement or compliance with that award would have ruined the respondent, in this case, the debtor, and of course would have also put the claimant and the creditor at that time in a very difficult position, in the sense that the debtor in that arrangement, or the respondent who also was the judgment debtor, the award debtor, was someone who had a specialized service which the claimant relied on, and which at that time in that particular country, and this was in South Africa, nobody else could offer the same service. So at the end of the arbitration, there was an award which helped determine what the rights of the parties were. And then Mahatma Gandhi encouraged his client to now embrace mediation. And through mediation, we were now able to work out the terms of settlement in terms of how the payment, yes, the award sum was now to be paid. And the advantage of that mediated arrangement was it allowed the company to remain solvent, because if it had paid all the money at once, it would have gone into insolvency. It allowed the company to remain solvent, and it allowed also the company to provide the critical service which the claimant required. So at the end of the day, mediation and of course, negotiation saved the day. Now, I'm sure that many of you have heard about this, but I put this slide all the same, just in case there are one or two people who do not appreciate sometimes the drawback of litigation when it comes to issues of debt recovery. So the cost of litigation, court fees, lawyers' fees, and a host of others are factors that sometimes can be a challenge in managing debt recovery, and it could escalate very quickly, especially if you have a client has entered a fee arrangement with a lawyer where you are talking about appearance fees and all that. And note that as especially for the younger ones, and if you are not already taking your money in that regard, please ensure that you do. When you go to court, even if the court doesn't see it, you have appeared in court. And so you are entitled to your fees, and you should take that money. Then time commitment. The legal process in terms of litigation can drag on for months or even years, as I pointed out. When we litigate, especially debt issues, please note that I'm not in any way saying litigation is bad. I practice law as a litigator. I'm in court regularly, but my practice is that, or my focus or my admonition is that only litigate that matter which must be litigated. So if you litigate, you are putting into the public record matters that ordinarily should not be in public record. And in some cases, especially when you're dealing with financial issues, there's the potential that parties' privacy will be affected, and then this has the impact of affecting your future financial dealings. You have limited control of what the outcome will be because the final decision rests with the judge, leaving parties with little or no control over the outcome. In fact, a point I must emphasize here is that in some cases, you may even win in terms of the outcome of the case. You may succeed, and at the end of the day, the court has determined in your favor, in favor of your client, but the victory is to a large extent a Pyrrhic victory. And so essentially, it looks like you've lost. You are pursuing a claim of 10 million naira. You've been in court for 10 years, and then the court rules in your favor. But 10 million naira in 2024 is not the same thing as 10 million naira in 2014. And that's an important thing to keep in mind. And then, of course, the rigidity of the process. It resolves disputes in the strict confines of the courtroom and court rules and at the convenience of the court. Most of us who practice law will know that when a judge gives a judgment, the judge usually will say, based on the evidence before me, which suggests that there may be some evidence that may not necessarily come before the judge. One of the advantages of mediation and negotiation, as we'll see down the road, is that there are certain issues that that relate to parties that are not necessarily distributive. When I say distributive, they're not necessarily about Naira and Kobo, but they are factors that have led to the dispute between the parties. So on the surface, it looks like a financial dispute, but in some cases, it goes beyond that. Sometimes it's about relationship, and that is important. So that brings us to exploring mediation and negotiation for debt dispute resolution. So what is mediation and what is negotiation? So we'll attempt some definition here. So mediation, this is a voluntary and confidential process where the parties are assisted by a neutral third party, the mediator, to reach a mutually acceptable resolution. It is important to note that the mediator does not impose a resolution of the parties. Or let me put it differently, the mediator does not decide for the parties. Rather, the mediator provides a structured negotiation process, providing what we call procedural fairness and a balanced discussion, leading to a collaborative solution, or otherwise referred to as a solution which belongs to the parties, a solution which provides the parties a joint benefit. So this is most suitable for instances where preservation of relationship is important. And let me add, particularly in business disputes. Again, I referenced the case of Mahatma Gandhi I talked about. If they had not deployed mediation and one party just insisted on enforcing their right, at the end of the day, they would all have been losers. Negotiation is defined as a process where parties by themselves or their representatives reach a mutually agreeable resolution to their dispute through communication and compromise. It is most suitable for debt dispute emanating from simple contracts and agreements. It is interesting to note that whilst mediation is third-party assisted, negotiation is not necessarily third-party assisted. In negotiation, the parties or their representatives attempt to work out the solution by themselves. But it's also important to state, for those who are new to processes like mediation, that the process of mediation is actually a process of negotiation. And for those of us who are practitioners in mediation, we call mediation facilitated negotiation, or otherwise referred to as negotiation with the help of a third party. Now, for those, I don't know how many of us are involved in helping banks do loan recovery, but my experience as a practitioner, and have had the privilege of doing some work in loan recovery over the years, I found out that many times I have been more successful on many occasions, rather. I've been much more successful in reaching an outcome that is beneficial to the bank using either negotiation, not mediation in this case, negotiation, than to file a lawsuit for recovery of the loan. In my experience, I've discovered that sometimes the reason why parties are unable to pay are because maybe the bank has taken a rigid position on the issue of, for instance, interest and penalties. And a negotiation that helps to, first of all, safeguard the principal, and then maybe a sizable amount of the interest that has accrued over the time, maybe in certain cases, waiving some of the penalties can sometimes go a long way to help the matter resolve quickly without necessarily going through the delays that you find in typical litigation. Further definition of the terms mediation and negotiation are provided in this slide. Basically, as I said before, it involves a neutral third party who facilitate the dialogue and helps negotiation between the parties. The mediator helps the parties to identify their concerns, explore their options, and reach resolutions which address their needs. The beauty of mediation is that all of this is done in a confidential setting, using a confidential process. In negotiation, again, the essential is for reaching mutually acceptable agreement between the parties. It involves discussions, concessions, and compromises to resolve conflicts and satisfy all parties involved. It aims to benefit all parties involved through effective strategies and tactics. So these are some of the basic things or ways of defining the two terms which we have talked about. Now, what are the advantages of negotiation and mediation for debt recovery? A major advantage is cost effectiveness. It's affordable. The lower cost compared to litigation due to reduced legal fees. So you will find, and if you've worked for banks before, you'll find that many times the banks will say to you, we would be happier if you could have this matter resolved through any other way other than going to court in the first place. So when we say reduce legal fees, let me say quickly, I'm not here referring to the fees due to the lawyer. We're talking about the fees, the expenses that you undertake to conduct the case. But one of the reasons why I'm making this clarification is that a major reason why lawyers, at least our colleagues, do not embrace mediation and ADR generally, mediation and negotiation for debt recovery, or indeed to deal with matters, is the belief that when they do not earn as much fees. So this is a trade secret I offer you for free this afternoon. When a client approaches you to conduct a case for them, onboard the case the way you would any other case. Whether you decide to deploy mediation, negotiation subsequently is a different matter. So typically at the consultation phase, if your typical charge is ₦1 million or 500,000 or whatever the scale of fees prescribes and you go by it, take a handsome deposit in lieu of that amount. Then, after you review the file, and I'm sure that most of you will take time to review the file, you can then advise the client that, well, yes, you have come to me and you say you want to go to court, but I have looked at it. We can use negotiation, we can use mediation. And in fact, what some of us do now is even to encourage clients or give them some confidence. Sometimes I even say to them, would you be willing to pay some more if I can have this matter resolved even faster than using the traditional way that you want me to? So the fees that are lowered here are, for instance, the cost of filing, and if you got judgment, the cost of execution of the judgment, and if the matter goes on appeal, all those processes that will come in. And of course, when we talk about cost effectiveness, we also look at the issue of efficiency. Faster resolution happens within days or weeks, saving time and a lot of money. I did a matter once, many years ago, involving a substantial debt on behalf, which was accruable to my client. Upfront, I was able to secure whatever was due to my firm. And then we were able to write a love letter. I call it a love letter, a beautiful letter to the organization from whom we were supposed to draw the debt. So to cut the long story short, the letter hit the right tone, meetings were held, and within a month, we were able to resolve a matter where if we had to go to court, the nature of the organization was one that would have had to serve them, first of all, a pre-action notice. And typically, most pre-action notice would be about 30 days a month. Then we would have filed the case. At the time when the client came to us, they came to us sometime in June. So if we issued a pre-action notice, that would have expired sometime in July. For most of you who follow the court calendar, you know that the courts will be on vacation between July and September, which means effectively that matter would have started only late September. By the end of July, we had finished. Our clients had received their handsome reward, and our firm had received the agreed fees. So cost effectiveness and time saving are very important in dealing with this, in using mediation, or there are major advantages in using negotiation and mediation for debt recovery. Then, of course, control. When parties undertake negotiation and mediation, parties exercise a lot of control over whatever the outcome of the decision-making is. If you surrender to litigation, if you surrender to arbitration, what you've done is to put the decision-making in the hands of a third party. But when parties sit at the table, and one of the things that I always say when it comes to matters relating to debt recovery, and indeed any matter relating to business, one of the things that I ask my clients when they come to me, and I'm sure many of you should, if you are not already, you should ask your client is, what really do you want out of this? If you check it, most of the time, it's a business problem. And if there's a business problem, then you should have a business solution. So we shouldn't bog the courts down with such matters. Rather, we should deal with those matters in such a way that we can exercise some control. And control could be the outcome being determined by mutual agreement rather than by a legal authority. That will also influence things like how the payment is made and so on and so forth, under what circumstances. Then, of course, relationship is preserved if you use negotiation and mediation, because it allows parties to maintain positive relationship post the resolution. In our African context, once you take someone to court, the relationship is not usually the best afterwards. It promotes cooperation. The case of Mahatma Gandhi, the matter which Mahatma Gandhi handled, promoted cooperation between both parties. And because the parties understood that it was in their enlightened self-interest, best interest, to be able to work out a negotiated set terms of payment that worked perfectly for them. The process is also adaptable to address the specific needs and concerns of parties. Negotiation and mediation can be conducted without necessarily the rigidity of following court diaries or timetables and so on and so forth. Many times I have, and I'm sure many of our colleagues who are online or many who have had this opportunity, I have conducted negotiations on Sundays. I've conducted negotiations sitting at an airport. I play golf. I've conducted negotiations in the course of a round of golf, leading to a positive outcome. And then, of course, naturally, if you do all of this very well, it will reduce the hostility between the parties and provides a positive atmosphere for building their future relationship. Another advantage is, as you saw from the definition of mediation in particular, there's confidentiality. Privacy is guaranteed. The nature of dispute and the settlement terms remain confidential. Nobody needs to know that you reach a settlement where a certain billions or millions were paid to you or paid to your client, and so on and so forth. So it safeguards the confidentiality for the client. It also safeguards the confidentiality for you. But if the matter was one celebrated, done in court, and then if it got the attention of the papers or the media, and these days social media, then everybody knows who collected what and how. And so this confidentiality actually also minimizes the risk of negative publicity for the parties who are involved. It's also easier to implement the outcome of negotiation and mediation because most of the time the solutions are reached by, indeed, all the time, the solutions are reached by the mutual agreement of the
Ladies and gentlemen, I think we've lost the moderator. I suspect he's having some technical glitches. So please appeal to everyone to exercise some patience whilst we try to get him back on board. So we'll continue shortly. I'm in touch with him and he's going to be online shortly. So please, apologies for the glitch and please stay with us. Thank you very much. I've seen a lot of queries about the presentation slides. So the slides will be shared to all attendees at the end of the training program, as is the practice. So I think Leonard Silk is back on. Leonard Silk.
I apologize. I got thrown out by
no,
the network.
These things happen. We're glad to have you back, sir.
Interestingly, I have 2 internet devices I'm working with, so I really don't know what happened. But let me just let me move along. Apologies to our distinguished participants. I'm just trying to find my presentation. Yes, I found it. Let me go back to share. Excellent. Okay. Can you see my screen?
Yes, we can see your screen, sir.
Okay, excellent. So let me just move this away and slideshow. Let's continue from okay, let's just start from the beginning and run it along. So sincere apologies, but I'll move it along now. I think I was at the final advantage. Yes, just a moment. Yes, I was talking about easier implementation, that it's a lot easier because parties reach the solution by themselves and have not, and it is not one that has been imposed on them by the third party. So it's also easier, implementation is easier because the parties having reached the resolution by themselves, there is greater satisfaction with the outcome, and then the reoccurrence of the dispute is unlikely in future. Of course, some of the solutions that come from using mediation, as you see there, some of the solutions are non-monetary solutions. So parties may agree on a non-monetary form of restitution. It could involve property, services, or assets as compensation for debt. Recently, I was able to work out a negotiated settlement for parties where some assets were put forward by one of the parties in place of money, because the reality is that money at this material time is scarce, and sometimes you need to think about options. So what negotiation and mediation essentially offer parties is options. It gives you the flexibility of planning. It gives you that flexibility of reaching outcomes that ordinarily, if you went to court, you would not be able to. Because when you go to court in litigation, and sometimes even in arbitration, you are bound by your claim and, of course, the responses that you put on. So you're able to set up a payment plan. In some cases, well, depending on how parties are able to work it out, they're able to work out outright payments. In some cases, maybe the claim is, say, 10 million naira. You're able to reach a negotiated settlement that says, well, if you receive 5 million naira now, that is full and final payment. And this can be done only by having a conversation sitting at the table. In other terms, it could be restructuring of the debt. Creditor may agree to reduce the total amount owed by the debtor. This is very common with recovery of bank debts and things like that, as the case may be. Now, what are the effective strategies for debt resolution through negotiation and mediation? The first I would recommend is that you identify interest and priorities of the parties. Focus on the interest. Parties should have prioritized interest over positions for a successful resolution. So for me as a practitioner, what I normally do when parties come to me is I ask them a very a question that many of them never think about. I ask them, what was your relationship with this party before the dispute arose? What kind of relationship did you have? Sometimes what they say to you will reveal that in many cases, parties were friends before they decided to go into business, or that a friendship relationship has developed over time. Again, compromise, being able to find a middle ground is essential for effective negotiation and mediation. For you to help parties, you also need to use effective communication skills. And when we're talking about communication skills, here we refer to both verbal and non-verbal communication skills. So it's important that positions are clearly articulated and that parties understand each other clearly. It's important that parties appreciate what we call non-verbal cues. Here, many of us take for granted what non-verbal communication cues are. And sometimes we do not pay attention. We only listen to that which the person is saying by their word of mouth. However, my experience in mediation and negotiation has indicated that sometimes you need to listen to that which is not said. And the way to maybe help our participants and the audience appreciate this is the saying that goes, actions speak louder than words. So somebody may be saying something by words to say this, oh, I have no problem with them, but by their action, by their body language, by certain non-verbal cues, that is certainly clear that there is a dispute or there's tension in their relationship. You need to learn to build rapport and trust. And you do this by preserving relationships. Negotiation and mediation methods aim to maintain relationship while resolving the dispute. So what negotiation and mediation does is to help the parties not to see themselves as opposites or opponents, but rather as partners in a process of trying to reach a negotiated settlement, one that works for them. Of course, the building of rapport is attractive because it helps to preserve the relationship, and this makes the method more appealing in conflict resolution. Many times, even when parties, there's a matter that we were involved in, it was about property. There was seemingly some amount that was due, payable, had not been paid, but the parties had a long-standing relationship, one that started from their secondary school days. We were able to reach a resolution of the matter, and one of the parties confessed that, you know, since this matter started, I haven't actually been sleeping. I'm very pleased that we're able to reach this consideration. And guess what? The final resolution, this party had to give up about, let's say, 25% of what they were pursuing originally, but yet they felt a sense of peace. So building that rapport and trust is key, and is one of the advantages of using these strategies. Of course, these strategies also helps you to explore alternative solutions. Earlier on, I talked about non-monetary alternatives, for instance, exchange of goods and services for payments. In some cases, a party is due to pay, and then the alternative, maybe I'm owing some money. Let me give us an example. I won't mention the bank, I won't mention the organization, but many years ago, an organization took a loan from a bank to start up a business. And then a dispute arose. The loan was due by the bank, or the due date for the loan had arisen, and the bank wanted to foreclose. Indeed, the bank, I think, even foreclosed, and then got judgment, and then it was now to execute. If it executed, the bank would be able to move the equipment which the loan was used to purchase to the court premises. But the nature of the industry was such that once you move those equipment, the equipment lost their value immediately. Two, if you put it in the court premises, they will lose further value because they are specialized equipment. There's no facility for preserving them. Three, finding buyers of those equipment would be quite a challenge. And four, even when the judgment was executed, the bank was not likely to get up to 50% of the outstanding loan. Guess what was the solution that was explored? The solution that was explored was for the bank to give that organization further loan to help it now conclude the process, to go beyond the stage of bottleneck, which it had found itself, to then open the business, and at the end of the day, to be able to deliver on its good. That could only have been achieved in negotiation, certainly would not have been achieved in the court process, neither would it have been achieved in arbitration. So at the end of the day, they reached a solution where the bank, which was being owed money, which had gone to court, had got judgment, now advanced the organization further facility, but on the condition that it put somebody on the board of the organization as financial director, and with that flexibility in the arrangement, exploring the alternative, they were able to work it out. And of course, lastly, you need to document the agreement. And it's important to document all agreed upon terms in writing for clarity and for future reference. Do not take it that because it's negotiation and mediation, there is no need for documentation. It is imperative, like in any other circumstance, to document, because you may find situations, and even though that is not my remit for this afternoon, you may find situations that even though the outcome was a product of a negotiated or mediated settlement, at some point you may need to enforce such settlements. They are not common, but there are certain instances where you have to. Then, of course, let's quickly talk about the lawyer's role in resolving debt dispute through mediation. The first is that you undertake what I call a case evaluation. So assess the merits of the debt dispute and determine if negotiation and mediation is suitable. Why is this important? It may not be suitable in every circumstance. The behavior of parties, the conduct of parties, the nature of the dispute, the nature of the industry may make it unnecessary to attempt negotiation and mediation. In some cases, you may actually need to litigate and reach a resolution in litigation, a determination by a court, a judex, before you put forward any efforts at a resolution through mediation or negotiation. And then, of course, it's important to, when you have done this evaluation, it helps you to choose the dispute resolution mechanism. So choosing the most suitable dispute resolution mechanism after a thorough case evaluation is very important. While negotiation and mediation are fantastic tools, sometimes they may not be the best or the only tools out there. There are several other ADR mechanisms that are there. There's conciliation, a model of ADR which can be useful. There are other mechanisms called expert determination, early neutral evaluation, and so on that can also help. A case analysis, evaluate the legal merits of your client's case and identify potential weaknesses. This is important because if on the balance of convenience, your case of your client is rather weak, or even if your client's case is strong, the chances of success is not very great, or the nature of success is not the type that you may be able to do much with. It is wiser to deploy mediation and negotiation. Develop realistic goals. Based on your case analysis, set realistic goals for the mediation and the negotiation. If parties come to negotiation and mediation with the same grandstanding that they take to litigation and so on and so forth, then of course, negotiation and mediation will fail. And then prepare your client. Advise clients on their rights and obligations, gather necessary documentation like contracts, statements, communication records, and prepare them for the negotiation. One thing that sometimes is very pedestrian, but I found out to be very pedestrian, but interestingly, it happens, is that sometimes lawyers and parties who have a case don't even look at their documents hard enough. There's a mediation which was conducted recently by a colleague of mine, a dispute that had been in court for 11 years. The mediation was concluded in 17 minutes. Why? Because by the time the mediator looked at the documents which both parties had put forward, it was apparent that there was no dispute between the parties. What one party was saying as against the other party was clearly compatible, but because they were blinded by the anger, the hate, the need to punish each other, they were not able to see it. These are the things that drive us in litigation and sometimes in arbitration. These are the things you do not find most of the time will not be there in negotiation and mediation. So mediation, negotiation, give parties the opportunity for a realistic assessment of the issues. Then, of course, develop a negotiation strategy that aligns with the client's goals and considers possible solutions. I'm not in any way saying that you should give up on your client's interests or the rights, but work it out in such a way that helps both parties. A key point to state at this point is negotiation and mediation will only be relevant to parties who are in what I call an ongoing interdependent relationship. If the relationship is an important one for both parties, then negotiation and mediation can help. If there is no importance, or if the parties are driven by their egos, then negotiation and mediation may not help. All the other requirements, prepare for the other party's argument, basically look at what are the things inhibiting them from reaching a settlement in negotiation. Communication and advocacy is key. That's what our work as lawyers is. So you need to find a way to advocate and communicate your client's interest, but in a non-aggressive way that the other party can feel comfortable. And then in drafting the terms of settlement, it is important that terms of settlement are drafted in such a way that they also do not call to attention fault for either of the parties. And this is very key. The language with which you structure the terms of settlement in negotiation or mediation will help parties decide whether they are willing to sign those terms or otherwise. What are the benefits of applying these mechanisms? I already talked about this, but for emphasis, flexibility. It allows parties to reach agreement through persuasion driven by the parties themselves. It helps to preserve relationship. It promotes settlement of the parties, which resolves ultimately the issue in dispute. And then there's increased chance of a win-win outcome. What do we mean by a win-win outcome? A win-win outcome is an outcome that has both parties walking away from the table feeling fairly satisfied that their interests and their needs have been met. A win-lose outcome is typically what you find in a determination by a court, because the court will find in favor of either the plaintiff or find that the plaintiff has failed to prove their case, and in that case, we'll find in favor of the defendant or the respondent, as the case may be. Same applies most of the time in arbitration. In negotiation and mediation, parties are able to reach settlements that work for both of them, essentially gives both of them an opportunity to win. So in conclusion, negotiation and mediation are highly effective methods for resolving debt recovery issues. By applying effective strategies, parties can navigate debt issues successfully and reach mutually beneficial resolutions. I thank you for your attention and for listening, and I'm happy to take any questions that you have at this time. Thank you very much. Dr. Kubi.
Thank you very much, Leonard. So thank you for the very insightful and detailed presentation. I can see questions are pouring in torrents, and we're also having a deluge of feedback and commendation, and we'll take both of them as time permits. Okay, so
Thank you very much.
let me look at the questions. You're welcome, sir. So the first question I have here is, what happens when a debt is statute barred and the creditor writes to the debtor to solicit admission and the debtor denies? Does the denial revive the debt?
That's a good question. I had stated earlier on that admission will revive the debt. Of course, the denial only reaffirms the fact that the man says he or she does not owe you. Let me say that if the letter, there are ways that you could couch a letter that you could draw a party out, but that is not something that's not a trade secret that I'm willing to give up very casually over over a Zoom interaction. Let me just say that once a matter is started bad, it's dead. But an admission, yes, will revive it. If a party says, no, I don't owe you, well, then I do not see how it revives it. But then, but there are ways that you could draw a party out. But that's not for, that discussion will not happen here.
Thank you, Leonard Silk.
Yeah.
So, Leonard Silk, someone has asked, how can parties appoint a mediator?
Okay, a good question. So typically, the way it works is that there is no law. Let me start, first of all, by saying that there are no laws, and not even the AMA provides. The Arbitration and Mediation Act 2023 does not provide that a person must be of this qualification before they can be a mediator. However, permit me to use the common pidgin phrase, better soup na moniculam. And just as none of us here, if we had a case, would go to retain a lawyer that is not competent, it would be wise that if you want to appoint a mediator, you do your homework. So do your due diligence. So my advice would be, there are a few organizations in Nigeria who have trained mediators and who have membership that warehouse mediators. There are also a few ADR institutions that are there. For most of them, and forgive me, but my bias is obvious, is the Institute of Chartered Mediators and Conciliators, where I had the privilege of being president, and I left office on the 28th of November last year. Now, you could write to the president of the institute requesting that the institute appoints a mediator for the parties in the dispute. For mediation, the number of mediators can be either 1 or 2 or 3 or 4 or 5, as the case may be. You do not need an odd number panel of mediators, because the mediators do not decide for the parties. The role of the mediator is to assist the parties reach a settlement. So if you have two parties who have agreed either by contract, either have an agreement in contract that says they should go to mediation, or post a dispute arising have agreed that they want to go to mediation, they can decide to appoint, each of them appoint a mediator. And like I said, you can approach the institute. There is also a lot of database out there. If you Google, if you go on LinkedIn, you can also find people who hold themselves out as mediators. What I will always advise is that please do your due diligence. My recommendation will be go through an established institution to appoint one, especially when you do not know much about the process of mediation or how mediators are. But parties can appoint one each. Parties can also decide that they want to have 3 mediators. They appoint one each, and then they have the 2 who have been appointed will appoint the 3rd. Parties can also agree that they will have only one mediator and make conscious effort to work towards reaching agreement on the person of who that mediator is. I must say the caveat is that that is usually easier said than done. So the safest way is always to get parties to appoint one each. But also note that the number of mediators or number of neutrals you appoint will determine how much you pay in fees. So if it's a simple dispute, simple contract, simple debt issue, please work hard to agree on one person so that parties are not exposed to a huge fee they have to pay.
Thank you, Leonard Sok. I think someone had even earlier asked, that's Olushina Odugua. He asked, please, where is the ICMC office in Lagos and who can I contact?
Okay. The ICMC office, I can't give you the address by heart, but it's interesting to note that the current president of the institute is a Lagos-based practitioner. I handed over to Godwin Omoka, senior advocate of Nigeria. Godwin Omoka is of Templars. So if you are able to reach out to Godwin Omoka, SAN, he can reach you. There are also a number of very eloquent and very qualified mediators, amongst them Dr. Adeyemi Agbelusi, who is also in Lagos there, and a host of others who are Lagos practitioners can assist you. However, I think the easiest thing you can do is to just Google the Institute of Chartered Mediators and Conciliators, and you'll find all the details in terms of the address. The headquarters is in Abuja, and then the addresses of the different branches will be available on the website.
Thank you, Leonard Sok. So Brian Efford has asked, please, how do you enforce an agreement obtained by negotiation?
Okay. How do you enforce an agreement reached by negotiation? First of all, Brian, if the parties reach the negotiation by themselves and with sincerity of purpose, to a great extent, there will be no need for enforcement of that agreement. My experience is that, and research has shown that in 75 to maybe 90% of cases, when parties have reached agreement on their own terms, without any coercion, they usually are able to undertake the implementation by themselves. But there are instances where, yeah, a party may be recalcitrant, either due to factors beyond their control or maybe out of mischief. The way to enforce that is, remember I had stated that you should ensure that you document the agreement. If you've documented the agreement in an ad hoc process, a private process, maybe the two parties sat down with their lawyers and reached an agreement and put it on paper, that agreement has become a contract between the parties for the performance of the obligations stated therein. When a party fails, the other party can then approach the court for specific enforcement via specific performance. So you are basically approaching the court to make a determination and a declaration that this is the agreement of parties and the other parties should be compelled to perform their obligation under the contract. If the agreement was one reached under the auspices of, say, for instance, a multi-door courthouse, say at the Lagos multi-door courthouse, the Abuja multi-door courthouse, or any of the several multi-door courthouses, then following certain procedural steps, that agreement may be endorsed by the ADR judge, giving it the force of law. It becomes like a judgment of the court. And that agreement so endorsed can then be enforced under the Sheriff and Civil Processes Act, just the way you would enforce any judgment of the court. But this applies mainly to mediated settlement agreements. Most of the time when parties reach agreement in negotiation, our experience is that they uphold the terms of the agreement.
Thank you, Leonard Sok.
You're welcome.
Okay, sorry. I was thinking I had gotten offline. So let us say there's a question. Isn't it better to stimulate mediation between adamant parties by court filings?
How do you, when you say stipulate, how do they?
Stimulate, maybe
sorry?
In terms of instigate them to mediate.
Oh, okay. Yes,
so
of
she
course.
Says, isn't it better to stimulate? Yes.
Oh, stimulate, yes. Yes, and let me make it.
Yes.
Yes, let me
maybe
confess that I have designed what I call LitMed. LitMed. It's not been. We are still testing it, and LitMed is a process where I know that mediation can help parties, but some of the parties have come or are grandstanding and are behaving in a way that indicates that they think that they are the alpha and omega and that they really don't need to come to the table. So I will go to court to force them to come to the table. And so sometimes when you file a robust writ, or in terms of an originating process, that sometimes may help the party to realize that there's a need to have a conversation with you. I go further sometimes after filing the writ and upon an appearance being entered by the defense to urge the court to direct the parties to attempt mediation. And in many cases, we have enjoined the court to direct parties to go to mediation. For instance, the majority of my practice is done in Abuja, even though I have the privilege of practicing in other states across the nation. But if I make that request, most of the time, especially because many of my lords know that this is my bias, many of times they are willing to accommodate that. And the lawyer on the other side, sometimes, even if they are not particularly willing, to save face, will agree that we'll go and attempt. And my experience is that once a party sits at that table, they are able to see things a bit differently from the way they were seeing it when they were sitting either in the courtroom or when they were just looking at the processes. So yes, I agree with that point. You can stimulate someone to go to mediation. And I have not registered the copyright yet, but I'm looking to promote LITMED, litigation mediation, as a way of stimulating that kind of process.
Thank you, sir. I think we should take some feedback before taking more questions. So Uchenna Ojembe here says, thank you, sir. Very insightful. Victoria Lekwa says, thank you very much, Leonard Silk. Winifred Cole in capital letter says, thank you, sir. Victoria Ojuola says, wow, this is very robust and insightful. Oluwato Sinaribo says, thank you very much, sir. Yakubu Mohammed says, thank you, sir. Samuel Andrew says, thank you, Leonard Silk. Honestly, I've learned a lot in capital letters. Victor Ijoma says, thank you, sir. Victoria Lekwa, this was a great use of 1 hour. And I totally agree with that. Maureen Nero says, thank you, sir. Same from Uzo Homen, Iemu. No goal. Adeniron says, thank you so much, very Leonard Silk, so insightful. Ebube Victor says, thank you, Leonard Silk, indeed, very insightful. We have a lot of thank yous. Olusegun, Ogumbanwo, Stella, John. Shane Borry Yange says, thank you, Leonard Silk.
I'm grateful for all the thank you. But I'm sure the questions, I mean, don't want the questions to suffer.
There are so many of them.
Thank you to
Abayomi says, thank you, Leonard Silk, for the brilliant presentation. I really enjoyed the session. Okay. So let's take a few more questions.
Okay.
Alphonsus Negbedion says, you mentioned writing a love letter to the debtor organization, and in 1 month, the debt was paid. Can you share essential elements of that love letter?
Doc, you know that I'm sure I think you should put it out there that, you know, when facilitators come for the ICLE program, they give up their time for free. So, so what they ask me is to, I'm giving my time for free. I should now also reveal my trade secrets. Anyway, let me just say that I will not be able to give too many details other than to say that do not write the letter in a threatening manner. Don't write the letter in a threatening manner, because sometimes it's the way you, that's why one of the things that I have learned over the years is to try to communicate with people, sometimes not calling attention to their fault, but calling attention to the benefit. So in drafting the letter, sometimes what I try to do is to highlight the benefit to both the organization and to my client if this matter could be resolved in a non-litigious manner or in a non-adversarial manner. And I've been lucky, let me put it that way. Sometimes we're not that lucky. I've been lucky that many of the, either sometimes the company secretary of the relevant organization or the CEOs have seen the advantage that we try to highlight in such a letter. And that's why I call it a love letter. But anybody who wants further details will have to come for consultation. and you know you have to pay.
Thank you, Leonard Silk.
Okay.
And Chioma Okolo asks,
Yeah.
please, who pays the mediator in a case where a party asks for them to resort to mediation?
Okay. So typically mediation, where a party may request that both parties go to mediation, but for mediation to work, both parties need to agree, because mediation essentially, and indeed negotiation, they are both consensual processes. They are processes that parties come to voluntarily. So normally, both parties will bear the cost of the litigation, and they will bear it equally, either mediation or negotiation, as the case may be. However, it's been my experience, not in debt recovery matters anyway, but it's been my experience doing some mediation. I won't mention the organization, where maybe because of the nature of the dispute and because of the imbalance of power between the parties, one of the parties will take on the responsibility of bearing the cost of the proceedings, but it would be stated in the agreement of the parties to mediate that the parties have agreed that one party who has the financial power bears the cost. The reason why I always insist that parties put that in writing is I do not want a party later to come and say, oh, it is because this person is the one that paid. That is the reason why it appeared that the agreement is skewed in their favor. And then, again, note that the mediator does not ever decide for the parties. The parties reach settlement on their own terms, in their own time, and by themselves. Of course, with the advancement in mediation now, there's a process called evaluative mediation, or put differently, court-connected mediation, where sometimes the mediator is encouraged to do a bit of pushing, prodding, maybe an encouragement, a bit of encouraging of the parties to work towards a particular framework of settlement. But in the final analysis, it is the parties who still reach that agreement by themselves. I hope that
Thank you, Leonard
provides
Silk.
context. Yeah.
Absolutely.
Okay.
Uyoyo Adekola asks, how do I convince an unwilling adverse party, that is the debtor, to submit to mediation?
Okay, very good question. How do we convince adverse parties to come to the process? The first benefit the mediation offers is that when using my own strategy is to say to the other party, one, is this relationship an important one to you? If that relationship is important, then two, let's have a conversation. I try to explain to them that the process of mediation essentially is like having a talk show. It's like an opportunity for a face-to-face conversation. Remember that the process of mediation, unlike litigation and arbitration, the process is non-binding, only the outcome is binding. So you encourage that party to, because sometimes all people need is an encouragement to come and sit at the table. So encourage that party to say, come, let's sit at the table. As long as you do not sign anything, nothing is binding on you. But once we begin to have that conversation, I begin to express my views, my pains, my concerns. It probably, in many cases, it becomes clear that what the issue is between the parties is, in some cases, about ego. Let me give an example. There was a matter involving an elderly man in some part of this country, in a part of the country where respect is a big deal. I won't mention the part of the country. And then, I mean, the respect is a big deal everywhere, but in some parts of this country, it's a major issue. So this gentleman was, an elderly man was owing a younger man who had done some job for him. He had finished, and then there was a balance of 2 million naira. And you know how sometimes people delay to pay. Because he delayed to pay, the young man then used certain words, and the older man was very upset. And then said, oh, is it because of this money you are insulting me? Okay, you have to come and collect this money. Do your worst. And as the case would happen, the young man went to court, engaged the lawyer, filed a suit and everything. It took the intervention of the judge, who was very mediation aware, to say, look, I look at this matter, there's really nothing here and all that. Please, you people go and attempt mediation. In mediation, the old man said, look, you want me to pay somebody who insulted me money? Yes, I agree, I'm owing him, but I will not give him the money because he insulted me. And of course, through certain negotiation strategies, communication efforts, and all that, it became apparent to the young man that an apology was what, it became apparent to the mediator. And again, the mediator was able to show the young man that what the old man really wanted was an apology. As soon as the young man gave the apology, the old man agreed to pay and indeed brought him cash and paid him. So these are some of the things that happen in typical mediation process that you won't see in other processes. Yeah.
Thank you, Leonard Silk. So Udochukwu also has asked, can a lawyer act as a mediator over a client's matter, especially if both parties are not opposed to it?
Very, very, very good question. Very good question. Can a lawyer act? There is nothing that precludes you, as long as you are able to win the confidence of both parties. And the only way to win the confidence of both parties is to remind both parties that once you take out the garb of the mediator, you are going to be helping both of them to see the two sides of the coin. Because really, when there's a dispute, it's about helping parties see both sides of the coin. It's about helping each one to appreciate the needs and the concerns of the other. Sometimes even when it comes to issues of money, I have had the privilege of helping manage disputes where somebody is owing the other person. And at the end of the day, what is in issue is something that probably happened many years ago, which one party feels that the other one was insensitive about. And that's why they've latched onto the opportunity of the debt to punish the other person. So mediation then availed them the opportunity to address those concerns. So the lawyer can, but you have to be very careful. I have had the privilege of being mediator in a matter between, not in a debt issue, but it was a matter involving, it was a matrimonial issue, a matter between a man and I was representing one of the parties in a divorce matter. The lawyer on the other side was a bit difficult, but at the end of the day, I invited both parties, asked them to please sit down, explain to them that I'm able to help them in this regard if they give their consent. But in most cases, I would rather not. I would rather that the lawyer stays as lawyer, and it will take a lot of experience as a mediator to make sure that you do not muddy the water. So if you do not have a lot of experience, it may be safer to just recommend another mediator to the parties.
Thank you, Leonard Silk. So Fatima Yahaya has asked, can mediation and negotiation be encouraged where a loan agreement specifically states arbitration as ADR?
Yes. Parties, there's what we call the principle of pacta sunt servanda. I'm sure most of us are familiar with it. Parties are bound by the agreement. But then it also, the same principle also recognizes what we call the principle of party autonomy. So parties may agree that in an agreement that they can go to arbitration. But prior to the arbitration, or even in the course of the arbitration, they decide to have a conversation with each other. And they see reason why the dispute never should have arisen, or they now are they now better understand each other with regards to the issue in dispute. They can work out a settlement, and that settlement is enough. And please note that even though parties, yes, in the agreement have said they will go to arbitration, one of the ways that parties can walk away from arbitration is if together parties agree that there's no need to continue with the arbitration. Arbitration is said to be binding to the extent that one party cannot unilaterally withdraw from the arbitration. But both parties can decide that they don't want to arbitrate anymore and that they would prefer to mediate or prefer to negotiate. A safety valve, however, is, and this is what I would do as a practitioner, especially if it's a debt-related issue, is to have the parties reach an agreement in negotiation or in mediation, depending on which one they have chosen, and then present that agreement to the arbitrator, who can then enter it as a consent award, such that if a party then fails to comply with the terms or decides to become recalcitrant subsequently, they have an enforceable award which they can push through the process of enforcement. I hope that clarifies the issue for that person. Thank you.
Thank you, Leonard Sok. So, Ajulu says, my understanding is that mediation and negotiation are without prejudice, and as such, parties may not be able to use any admissions or outcomes during mediation or negotiation in the event that mediation or negotiation fails and parties decide to litigate. Is this still a valid position, or are there exceptions?
This is the position. And in fact, that is one of the major considerations that encourages parties to embrace mediation or engage in negotiation. The fact that the discussions are without prejudice. In fact, in terms of mediation, the process is confidential. Even the outcome is confidential. And it's only maybe for the purpose of enforcement, as the case may be, that you could do that. So is that still the position? Yes. And it is one of the things that I use as a selling point to convince reluctant parties to embrace the process of mediation. Because I said to them, you lose nothing. Let's have a conversation. As long as you don't put anything in writing, it doesn't bind you. And no court, and again, if you look at the AMA, no court will countenance any information, review the mediation before in the litigation process. The mediator has immunity, and the mediator also cannot be called to give evidence against any party as to what was revealed to them in the course of mediation.
Thank you, sir. Iba Damla has asked, if a demand letter is served on a debtor and the debtor fails to respond, does it automatically amount to an admission?
No, it doesn't automatically amount to an admission, but it makes proof a lot easier. I mean, if I send you a demand notice and you're owing me money, you choose not to respond, you ignore me, and I file a case in court, and I'm able to demonstrate by documents that indeed you're owing me, and you still choose not to come forward, you are making the work very easy for the judex to just decide. But of course, I must still prove that you are owing me money. I must prove, first of all, that there was a contractual relationship or that I offered you services. I must prove that I performed those services and that you have neglected or refused to pay, as the case may be.
An attendee has asked, thank you, Leonard, so has asked, can mediation and negotiation be effective when the supposed defendant is very aggressive?
Okay, that's a good one. Can it be effective? Yes, it can be effective. Sometimes when we train mediators, one of the aspects of the training that we offer our colleagues whom we train as mediators is an aspect called understanding human nature or understanding human psychology. So the mediator must be a what I call a wordsmith, someone who knows how to use words in the way that helps to de-escalate conflict rather than enhance it. Also, it's important to know that where parties are aggressive or behave in an aggressive manner, it may be wise not to bring them together immediately. So if you look at many, particularly with regards to mediation and negotiation, if you look at a lot of standard texts, they talk about bringing the parties together in a joint meeting, having, and then to identify what the issues in dispute are. In such circumstances, I would follow the strategy of meeting with the parties separately first before I bring them together in a joint meeting. So I can still help parties through that process using mediation and negotiation without necessarily, because sometimes the reason why people don't want to even come to the table with the other is, like I said, it may be because somebody has been very rude, very insulting, and all that. I've been briefed by a client who was willing to pay a substantial amount of money for me to pursue and recover 1 million naira because he felt his wife had been insulted by the actions of the other party. So these things can happen, yes.
Thank you, Lenny. So we'll take just 2 more questions before we draw the curtains.
Thank you, Doc.
Yeah, the next one is from Mustafa Bila. It says, assuming parties reach a settlement and time is fixed for payment, and the debtor failed to pay, and even after several demands, can it be enforced in a court?
Okay, So if parties reach a settlement, yes, and please note, I stated that you must document the settlement. If the settlement is documented, it becomes, as it were, a contract between the parties for the performance of the obligations stated therein. So if a party fails to comply, you will enforce it. My advice would be, and we have been promoting this, we are now promoting the parties and lawyers particularly should please refer their clients and the matters to our court-connected ADR centers. We have several. We have in Benin, we have in Delta, we have in Abuja, Lagos. Lagos is the foremost. We have in Kanu, and in a host of other states now have multi-door courthouses. If you take it through the auspices of the multi-door court, enforcement becomes a lot easier, where a party does not comply. But yes, but most of the time, my experience is that if the matter was handled properly, rarely would you find it difficult to have a resolution of the matter through negotiation or mediation, even in terms of the enforcement of such a matter.
Thank you, Leonard Silk. I'll take one more question and then feedback before we draw the curtains. So Sombo Yanga says, how are the proceedings? And I think a couple of people have also asked this. So I'll just take one. How are proceedings in mediation conducted in terms of the procedure?
Okay, I have 2 minutes, but I'll try and just give a basic overview of how a typical mediation, typically parties need to know about how mediation works. So lawyer assistant parties need to do their research about the process of mediation. You start by appointing the mediator. In some cases, for instance, let me use the framework of the court-connected ADR center. Say if you go to the Lagos multi-door court or the Abuja multi-door court house, which is Christian Uwe's Dispute Resolution Center, a party can walk in and file a complaint. When that complaint is filed, it's typically, I think, you fill the Form 1 or Form A, depending on the context of or what terminology the particular center uses. Then the other party is then given, notified that, I think via Form 2 or Form 3, that a dispute has been filed against them and they report, and they would like, the center would like them to agree to submit to mediation. As I said, if the relationship is an important one between the parties, then of course, typically you will find some party, the parties will agree to submit. Once the parties are all there, then the next logical step is for them to agree to appoint a neutral. At a multi-door courthouse or a court-connected ADR center, they have what we call the list of neutrals. So there are practitioners who have been accredited by the center as people who can be appointed either as mediator, arbitrator, and so on and so on. So from the list of neutrals, particularly in this case, mediators or negotiators, parties can jointly agree to pick one person or pick 2 people, 1 each as the case may be, or pick 2 and then the 2 appointed and pick 1 person. Please note that the appointment should be based on the complexity. The kind of person you pick, you should be careful how you do that so that you put your best foot forward. So that you can get the best of an experienced mediator, somebody who can bring to bear value for the time and effort. Even when it is, in some multi-door courthouses, it is cheap, it's cheap, they don't charge much money, but you want to make sure that when you submit your dispute to a third party, you want to make sure that that person knows what they are doing. Once the mediator is appointed, the mediator will then schedule usually the first plenary meeting within the parties. If the parties have demonstrated that they have good behavior and there's, even though they are not happy with each other, there is no tendency or likelihood for aggression or demonstration of anger or violence, then if I'm the mediator, I will bring them together in a plenary. At that plenary, I would have the opportunity of introducing myself to the parties, engaging with them, hearing the story of either side. And then after I've heard the story of either side, I will not go into attempting to negotiate there and then. I will usually break into what we call a private meeting, otherwise referred to as a caucus, where I will engage with each of the parties to find out deeper as to whether there are deeper issues at play, whether it's not just, oh, he's owing me money, he's not owing me money, I'm not owing money, but are there more issues? And that's what happened in the case of the old man and the young man in the particular state, as I mentioned. It was in the course of those private meetings with Baba that Baba revealed that the young man had insulted him, and that even though he was truly owing the young man, he would not pay because he had been insulted and all that. And it was also in the course of that meeting that the mediator was able to distill and understand that, okay, the critical issue here is an apology. And so when Baba was asked, would you accept an apology? He said, yes, but he must apologize to me. If not, I won't pay. So that's what typically happens. And once you achieve that in that private meeting and you are able to identify the needs, fears, concerns of the parties, you can bring them together again. There may be a bit of back and forth severally, and so on and so forth. All of these, I'm saying, are components of a very detailed 5-day training to become a mediator. So please do not, on the strength of this alone, say that you now know mediation. Please, this is just to expose you and give you an idea of how it works. And then, of course, if the parties are sincere with themselves and the mediator working with them, they walk through the negotiation phase, are able to reach a conclusion. And the conclusion is where they are able to knock out an agreement. A key thing that I must leave you with as we round up is that the agreement in mediation is always forward-looking. It's never backward-looking. And typically also in negotiation in many cases. And what do we mean by that? Is that the agreement is structured or written in such a way that it plans the future relationship of the parties. It does not talk about who is right or wrong. This is a very critical element in drafting, because if you do not draft it in that context, then you sometimes make face saving for the parties difficult. So essentially, this is how mediation works in a nutshell. Yeah.
Thank you so very much, Leonard Sok. I crave your indulgence to just take some feedback from attendees, because very important.
Okay.
Gloria Isa says, thank you, sir. This is really educative, time well spent. Jana Tuamet says, very practical, thank you. Ohiremen Ebore says, I never get tired to listen to you, sir. Usman Mohammed says, thanks, my friend and Oga, for the incisive presentation. Emmanuel Umoke has decided to write his own in capital letters. Thank you so much, Leonard Sok. Akimbo Deolato Kumbo says, rich presentation, sir. Hope we'll get the slides. Yes, you definitely will. Gloria Item says, very many thanks, Leonard Sok, for a job well done. Gloria Item is from Eket branch in Akwa Ibom. But okay, Emmanuel Abaje says, brilliant presentation, Leonard Sok. Brian Efort, your question was answered earlier on, says your presentation is apt and simple. Thanks, Leonard Sok. Lots of thank you. Georgina McEbong says, very grateful for such robust presentation. Thanks very much. Michael Moman says, very insightful. Thank you, Leonard Sok. There are loads and loads of thank you here. And Leonard Sok, I want to say that on behalf of Tobena Erojikwe, the chairman of NBA ICLE, and the rest of us here, we are profoundly thankful for your very robust, insightful presentation, very educative, and are very well spent. We thank you so much. Thank you for the time you used in preparing your presentation. We know, of course, your busy schedule, but we thank you for everything. We can't thank you enough, sir. And you can see the thank yous are still coming in. We'll leave the window open for the thank yous even after the end of this session. So thank you so much, sir. We're grateful. We can't thank you enough. We're profoundly and immensely grateful. And we hope that next time when we knock on your door, you will always open your door to us to come and share with us from your wealth of experience and in-depth and extensive experience. So thank you very much, Leonard Sok. We're grateful.
Thank you, Dr. Kubi, and thank you, the entire team at the ICLE. I mean, it's amazing. At a point, I thought that we had over 600 people in attendance.
Yes.
That's an amazing audience to have an online webinar, online presentation. I want to thank you, Tobena, and the rest of you at the ICLE for the team for the work that you're doing. I mean, many of us, as we grew up in practice, did not have these opportunities. And what I say to my juniors all the time when I see any notification from the NBA ICLE is, please make sure you attend, because these things are free. In some other jurisdiction, people have to pay for this kind of engagement. So well done. Thank you. And thank to everybody who has taken time to participate. Please, as we all are colleagues, if you see me on the street and you say hello and I do not remember you, just remind me that we met on the NBA Zoom platform. Thank you very much, and God bless. Have a wonderful day.
Thank you, sir.
Okay.
Thank you, sir. And thank you, members of the audience. Thank you for your time and patience. Don't forget to join us tomorrow by 2 p.m. Dr. Kemi Pierre will be speaking to us on efficient use of garnishee proceedings for debt recovery and effective defenses. 2 p.m. Nigerian time, West African time tomorrow. Once again, thank you for your patience and thanks for your participation. Have a great day ahead. Cheers.